6 in the morning. Question, okay, now what kind of phone does your Aunt Jennifer, what kind of phone did your Aunt Jennifer have? Answer, she had an iPhone. Question, and do you still have that text message in your phone today? Answer, yes. And did you look at that text message recently in the last day or two? Answer, yes. Question, now prior to the last day or two, when was the last time you looked at that text message? Answer, the day I sent it, November 20th, 2018. Question, so you haven't looked at the message since? Answer, no. Question, when you looked at it in the last day or two, what, if anything, did you notice about the text message or iMessage? Is it a text message or an iMessage? Question, or excuse me, answer, it's an iMessage and it changed from delivered to read. Question, okay, so do you have any idea what that would have changed? So do you have any idea when that would have changed? Answer, no, I didn't look at it for 7 years. Question, now the fact that it said read, did that stand out to you? Answer, yeah, because who read it? I wasn't allowed to read it. That deals with the testimony. At the original moment in time, the prosecutor did not object, however, did object last night as a result of not just this colloquy back and forth, but the next colloquy that goes on the record, which deals with Jesse's iPad. Question, again, same witness, Caitlyn Cano. You mentioned earlier Jesse's iPad. Answer, yes. Question, let me ask you this first. Did anyone in Jennifer, Keith, in your family share their locations with you? Answer, Jesse. Question, and was that tied to his iPad? Answer, yes. Question, okay, at some point, did you check the location of the iPad? Answer, yeah, in February of 2019. Question, okay, so this is a couple months later? Answer, yeah. Question, and where was when you checked the location, what was the location? We went to sidebar. This is when we learned that when the proffer came out. And we were informed at sidebar that when she checked the location, that the location would read from Corey's house. And that was the first time that the defense, the first time the defense put the state on notice of that information. The state had objected to that information. I had the opportunity to do some research on it yesterday during the time frame, but unfortunately, due to the fact that this information was sprung on everybody, including the court, I had indicated that I would accept briefs from counsel. That they were due by 10 o'clock last night, leaving the court between 10 p.m. and 8 o'clock this morning to come up with a decision as to this. I've reviewed the state's brief, which I received somewhere around 8 o'clock last night. It was authored by Mr. Decker for the state, in which the state argues that it was concerned about the actual two items of evidence, both being what was testified to and would be stored within the witness's phone, to include the actual text message that was marked read and also the location. In the state's position, the state indicates that this runs afoul to what was contemplated by the Supreme Court in Tier. They cite to a particular portion at the end of the Tier opinion, which says that we encourage practitioners to participate in cooperative discovery in order to ease the burden on all parties involved. But really what the state is relying upon is the fact that because this information was electronically stored in the witness's phone, that this information should have been turned over to the state, which it never was, and because it was not, that the remedy is now exclusion with an instruction that they should disregard the testimony. Then received it at 10 o'clock last night, the defense's response, and the defense's response, for the first time, defense counsel admits that she had an actual screenshot of the phone message, the text message, which indicates that the text message was read, that the screenshot was provided to her, according to her, the day before, and that she decided not to use it due to its late hour, and decided not to turn it over. That was her decision that she made, which is clear from her submission. So we'll deal with that issue as number one, as whether that is a discovery violation or not. The second issue deals with the issue of the location of Jesse's iPad. The defense is arguing that this testimony is relevant because it demonstrates that Corey was taking items from the house after the homicides, which lends to certain credence about that the scene was contaminated during the cross-examination of Detective Vogt about these Tiffany jewelry boxes found on top of the rubble. But, of course, this was dealing with when Vogt collected the DNA samples in 2020, not in 2018. Second, the state argues that it demonstrates, that this evidence demonstrates a failure to investigate because the state did not seize or search the iPad while they did seize and search Sophia's phone. The defense argues that the state, and I should stay there for a minute. In pointing this out, I want to go back for a minute to the text message. There was one thing I did want to add to that. In the submission, no, I don't need to go back. In the submission, it also points out that that when Katie learns of the location in February of 2019, that she sees that the location was at Corey's house. There's a footnote that the defense counsel talks about, which says, it should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it either via text or phone once she saw it that he had the location, and asked him why he had taken Jesse's iPad. That is the first time and only time that the court is aware of that either there is a documentation in a phone of either a text message or a phone call in Caitlyn Caneiro's phone that could corroborate or provide information that could be investigated as it relates to the issue of whether that occurred or not. That either text message or phone call was not turned over to the state, and if it was turned over, they can tell me when they start to argue. I should point out that the defense is, in saying everything that I've summarized so far, the defense is saying that they are not suggesting that the iPad was taken at the time of the murders, as it was clearly depicted during the testimony of the forensics detective when he went through the evidence found in the kitchen, where there was an iPad located there. The iPad, I guess based upon what defense counsel is saying, is that the iPad that's located in the kitchen is actually Jesse's iPad. I don't know if that was clear during the testimony at all, that somebody said specifically that they knew that it was Jesse's iPad, but that also is something that's being argued. But what the defense is saying, that they were trying to be careful to make clear to the jury that Katie saw the location in February 2019, a few months later, so not to be misleading. However, there was no context to this as to when, at that point in time, how long that the location was at Corey Caneiro's house for this iPad. It truly was unclear because we didn't get that far based upon where we were. Defense counsel further argues that the state had full access to Susan, Katie, and Marissa, that the state had the ability to interview them just as much as the defense did. However, what's interesting to note about that is that it's clear from this submission, and it's noted specifically as a footnote number 3 on page 4 of the defense's submission, that the defense was aware that the state was making efforts to speak with Susan and to Katie and Marissa close to the time of trial to make a decision on whether probably if they were going to call them or not. However, that none of them were willing to speak. So the state did not really have access to them. So when it comes to the defense putting in their submission that for the weeks during the course of the beginning of this trial that they were not sure if the state was going to call the either Susan, Katie, or Marissa, the court has some level of concern of that statement based upon the fact if the state had no idea what these individuals were going to say, why would they call a witness that they have no idea what's going to come out of their mouths other than a statement that was given 7 years ago, but now they're unwilling to speak to the prosecutors. So I'll leave that for another day or for the state to deal with if there's something that should be added. I'll point out that while the state did have Susan, Katie, and Marissa are on their witness list, the witness list is a list of people that may be called. It's not every. It's more people that are ever involved in a case. The witness list is used not just for the potential witnesses, but it's also for the jury to know, to be read each individual's name, so that if one of the jurors happens to know one of these individuals that may not be called as a witness, it's still important for the court to question those particular jurors as it relates to that issue on whether that if they knew that person, even if they're not being called, would that have impact their ability to be fair and impartial. So the fact that the Susan, Katie, and Marissa were on the state's witness list is of no moment to this court as it relates to them being there and as to whether that there was an obligation here to turn over this type of evidence. I also want to point out that counsel brings up the fact that, well, this trial is moving exceedingly fast. I just want to say that I've disagreed with that from the door. I gave the March 20th date because everybody indicated that that's how long the trial would be. It was never what the court thought that how long this trial was going to take. As the trial went on, it was clear that this case was moving quickly. As early as the first week, it was clear that this case was not going to take as long as what was being said of March 20th. So I don't find that the movement of the case in an expeditious way was any surprise to any of the parties as we move forward as to when the prep of Katie was done, or how ultimately we come to the conclusion of where we are today. So defense also talks about State versus Tier, and I'll get into that when I give my ultimate decision. And lastly, the state says that it doesn't believe that it violated any reciprocal discovery, but if it did, that it should be a brief continuance instead of a violation that bars the actual testimony. And there was 2 exhibits that were supplied with the defense's submission, which includes, again, a photograph. In Exhibit A was a photograph of the kitchen area where the defense is indicating that Jesse's iPad was located on there. And then, again, that's what the defense is saying. And then second was the actual screenshot that was never turned over. I summarize what people have said so that we don't need to reiterate the actual arguments. However, considering that the state submitted their submission before the defense, I don't know if there was something else that they wanted to respond to, but I'm going to allow both sides to create their record before the court makes its ultimate determination. I'll start with the state.
Thank you, Judge. Now, I just want to start off by saying that I think that the court's summary with respect to the issue that came up yesterday and the court's summary of what was stated in the briefs is spot on. I mean, I think that the court essentially hit every point that the state would have argued. Obviously, the state and the defense in any case have different discovery obligations. We're all aware of that. But that does not mean that when you are in possession of a document that you decide not to turn over because you weren't going to use, it doesn't mean that it's not a discovery violation. I mean, they did use it. They didn't use the physical document, but they used the information in there. That's where the state has a problem. I don't want to get on my high horse, Judge. I'm not going to belabor the fact because the court's spot on in its insight with respect to everything that it said this morning. But as someone who's been with the prosecutor's office for almost 23 years, especially in the last few years, I've had to sit back on cases that were not mine, some of which I then had to get involved in, where the prosecutor's office was being accused ad nauseum of these heinous discovery violations, when in effect, a lot of times it was essentially some sort of minor oversight, clerical error, but yet in the press, the state and the prosecutor's office was looking like the demon, the villain. I'd submit to this court that over the course of the last 7 years, this office, myself, Ms. Wallace, our paralegal team, our clerical staff, have done everything possible to make arrangements to provide discovery to the defense. I've been personally, not by these attorneys, personally had my credibility tarnished, or attempted to be tarnished, by a prior attorney for Mr. Caneiro, wherein I had to write a very scathing letter pointing out that in fact we did not have something at a certain point that we were accused of having and not providing. We've provided discovery. It's been gone over ad nauseum by Your Honor, by Judge Oxley, every status conference. Is there any other discovery? We've done everything we can. I'm not trying to make this more than it is, but I think based upon the submission that we've received from the defense, certain things are clear with respect to what they had, and I would submit to the court, as I stated, that I don't believe that the New Jersey Supreme Court in Tier intended for their opinion to mean that, hey, let's not document it because then we don't have to turn it over. I don't believe that's consistent with the language about encouraging practitioners to participate in cooperative discovery, etc. It's pretty it's pretty clear what we have here. It's a clear situation. The court's insight is spot on. With respect to the Susan and Katie and Marissa, you know, a lot of what Ms. Mastalone said is accurate. We did make attempts, and just because we didn't, Detective Petrozello or Detective Weisbrot didn't document every effort over the course of the last 7 years to make contact with the family, doesn't mean it didn't happen. They know it happened. We tried our best to not harass them, certainly, but we had made efforts. Ultimately, it culminated with, we were supposed to meet with them on the Friday before the first trial date in September, and it was canceled because we were here arguing whether or not Mr. Caneiro would be released. Then, prior to trial, we made efforts again. I did speak to Ms. Mastalone about it. She said that she was in contact with them and would tell them to give us a call. Ultimately, Ms. Caneiro called Ms. Wallace back and indicated that she didn't feel comfortable talking to us. So, they were on our witness list, yes, but as the court noted, properly noted, that we can't put witnesses on the stand when we don't know what they're going to say, i.e. exactly what happened yesterday. This is not information that was provided to us. It was not known to us. We would have objected to the first part of the testimony yesterday had we known it was coming out, which we did not, obviously. And then, obviously, it became clear with respect to the iPad location and that clarification that she saw it in February of 2019 does nothing to clarify to this jury when that iPad was taken by Corey Caneiro or his wife or whomever who actually had control of the property after the scene was released by virtue of the executive status. That being said, Judge, I'm not going to belabor this anymore. It's clear exactly what we have here. It was a document, it was not provided, and there was other information.
Let me ask you this question. If the court felt compelled that it had to allow some of this information, even if I do find a discovery violation, I just want to know the state's position as it relates to a need for time to investigate some of this information that you're literally learning five and a half weeks into a trial.
Judge, the testimony yesterday that she looked at, all of a sudden she looked at a text message and said read without the document, I don't give it much credence. The document's clearly not admissible. Her having testified that it was read.
Well, you know the document exists.
Yeah, but I mean, I would submit to the court it's clearly inadmissible. There's no question it's clearly inadmissible. It's provided after she said something on a witness stand. Judge, I worry about the credibility of what's been provided, how it was provided, how it became read. I have no idea, nor am I ever going to be able to know. No time is going to allow me to figure out how that became read. It's just impossible at this point in time. So I don't believe, personally, I don't know if Ms. Wallace would disagree with me, that time is going to do anything at this point in time. It's not going to allow me. I know I can find out when Ms. Caneiro's phone number was ultimately ported to someone else, which is what happens when someone's phone is ultimately canceled. But that doesn't provide access to the data within the phone in order to allow someone to read a message after the fact. It's just that document is just clearly inadmissible. Whether the court ultimately tells the jury to disregard the testimony about it, that would be the state's position. But as far as time, Judge, we try to move this case as quickly as we could in an expeditious way, in a thorough way, and the state is ready to finish this case.
Ms. Mastalone, would you agree with me that the document, the screenshot that you had, was an electronically stored document within Katie's phone?
The document that I had, Judge, was simply a screenshot of what she observed in live time.
So, but my question to you is that the actual physical phone that documents the screenshot, that physical phone and what's located there Do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discovery.
I'm asking you a question, yes or no. The answer is either it is, or in your opinion, or it's not. So
in my opinion, it is electronically stored in her phone. Yes. Is it electronically stored as far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it, according to you, the day before. So you did have access to not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time, and in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it. But I didn't think it would be fair to surprise the state with this document and say I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So, yeah, you did have time. You absolutely had time to turn it over, and it's not a fleeting moment. You knew with other text messages that you had, where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that witness took the stand. So the state, at least at that moment, could have had the opportunity to say, hold on for a minute, we want to do some research on this before it comes out on the stand. TIER says one thing, it does. But TIER does not mention, and it does not deal with the fact, when something, it's not created by you, no one's asking you to create anything in this case, it already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what TIER is talking about. This, in this court's opinion, aligns more with State versus Knight. That is a 2024 decision, which I'll get into in my decision, which directly, in this court's opinion, is a situation where the defense has certain rights, and they absolutely, there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it, and you didn't turn it over. So if your answer is anything other than when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Judge, frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something at trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all I can say.
That is.
If Your Honor disagrees, then Your Honor disagrees. That's all I can say.
I do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical screenshot in advance, so the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this. I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered tier. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record is clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using...
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate to refresh her recollection would have been what you had in your possession, which was the screenshot, which included underneath the word read, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form. The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning, so I guess this is during a conversation that you had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Maslone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record, as you just did, but the reality is simply this. You were given the opportunity, under these circumstances, to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to further my position that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise, and the court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times to make sure that it's okay to ask certain questions, as I did before Katie Caneiro's testimony. This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was it. There's a 25-page ex parte letter that pertains to Corey Caneiro. The court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that didn't seem to me to have the message about Jennifer's phone has nothing to do with Corey Caneiro.
Didn't I rule as it relates to any post behavior by Corey and/or his wife or ex-wife that I was not going to allow some of this conduct to be brought out? Didn't I say that in my January 27th?
Absolutely, and this wasn't.
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, it's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking. The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes, exactly.
The reality is this. It goes to his behavior. It doesn't go to the fact of something that happens in 2020. A contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
It wasn't elicited, Judge. If I can clarify, I was simply explaining that the Tiffany's boxes, those photos, those were taken in 2000, I believe, to early 2019, around the same time frame by the insurance company, if I'm remembering correctly. That was testimony about the Tiffany's box that was elicited, and Your Honor, I think, had said it goes to scene contamination because the swabs were not taken for an entire year later. Additionally, there was testimony about Elisa taking shirts or clothing from the house. That was prior to the swabs being taken. So there is testimony.
Who testified to that? Who testified to Elisa going into the house and getting stuff out?
It might have been a mix between Petrozello and Detective Vogt.
I think there
Who
was...
specifically testified that people went in the house, that they saw them go in the house and take stuff out? Or contaminated the scene?
Well, that would be Detective Vogt, not specifically as to the shirts, but as to the jewelry boxes on the floor of the master bedroom.
That he says what?
That he didn't place them there, that they appear to be the same type of boxes that were in the safe that was opened, and that he does not know how they got there. And clearly from the photo, they're on top of the fire jar.
I remember that. But who testified that somebody went in there and actually was touching this stuff?
Well, Detective Vogt did say that the person from AIG must have been in the house.
Okay.
And there was no...
You know what I'm asking you. We're not talking about AIG. We're talking about the fact, what's being said to me right now is that there was testimony that Elisa was in the house. Where in the testimony does it actually say that? Not based upon what you guys may know outside the testimony. What do we have in the testimony that says it?
I don't... I mean, at this point in time, I don't specifically. I don't have a recollection of exactly where that came in the trial.
Okay.
I know I didn't... I can say it didn't come in through Detective Vogt.
Right.
It may have come in through Detective Petrozello. I can't say for sure. I know it's a fact we knew. I know it's a fact we discussed. I don't know if it came out in the testimony.
Here's the problem that I'm having. I'm saying it to both of you. And I've said this before. You two know more about this case than everybody. Because you have institutional knowledge, number one, for having this case. But number two, about the intricacies that were going on behind the scenes. Just because you know it doesn't mean it was in the case. I'm having struggles even with this submission, because there's other parts of this submission that is talking about testimony that has occurred that I don't have any recollection of, or in notes and notes and notes, can I find it? So I'm not saying that I'm right. That's why I'm asking these questions, because I don't think it exists, and I may be wrong. So if you tell me that it exists, I will go and try to find it. Otherwise, I don't know how we're getting to certain leaps to make these connections without some testimony to support it.
Judge, the portion in the letter where I'm referencing it was just for context. It wasn't to say, it was for why this could be relevant. I wasn't eliciting specifically that Corey was in the house. That wasn't part of the testimony. And really, I guess I should have switched them, because I think the main reason I'm relying on it as probative is simply because it's a failure to investigate. What I also didn't include in the letter, because it wasn't something that also was not testified to, is that there was information contained in the discovery about Jesse sending text messages that his house was on fire. Now, whether that's a credible piece of information, I don't know. It was in the discovery, and they don't have the iPad. So from the defense's perspective, the fact that they did an extraction of Keith's phone, did an extraction of Sophia's phone, I never knew what happened to Jesse's iPad. I learned for the first time the day before she testified, or maybe it was a couple of days before, about the iPad, that she checked the location and that the rest ensued. I don't have any additional information other than that, Judge. It was a relevant fact to elicit. The state objected. If the court finds that the information shouldn't have been elicited, the court can obviously sustain the objection and or strike it. With respect to the iPad, there's nothing for me to turn over. I don't have anything. It's not, and I don't think, I do disagree with the state as far as what TIER is designed to say is to protect the defense's Sixth Amendment privilege and right to conduct a
This isn't a Sixth Amendment issue. It's electronically stored information, and it's not inculpatory against the defendant in any regard. Yes, I understand what you're trying to use it for, but you're trying to use it because the investigation could have been done better. However, you're trying to give context to things that are not in the case. And I've already ruled that certain information was not coming in. And what we're trying to do in this scenario is trying to elicit information for one reason and then leave it out there for whatever else it may be used for. And my problem is that I understand that for third-party guilt, that I should give as much credence as I can. These are not the exact words from the case law, but to try to give you the opportunity to do what you need to do. But this, I've ruled on this, and I think that this was something that's very concerning to the court. I'm going to take a few minutes before I make a decision. Prosecutor, is there something you want to say before?
Judge, I just want to clarify something that really is just for clarification purposes with respect to there was information in the discovery that Jesse may have texted other people that his house was on fire. That is accurate. Detective Mahoney's notes indicate that he had heard that. He then, other people, I don't remember exactly who, went to the school and determined that that was not in fact true. It was a rumor amongst 11-year-olds at school. So that's just to close the record in that regard.
I'll be back. Let's not bring up the jurors yet.
All rise, court is back in session.
Be seated. There was an issue before the court yesterday that the court summarized earlier in oral argument, but did not render a decision on the admissibility of the evidence when it was brought up at sidebar. Instead, the court expressed concern that the information, having not been previously disclosed to the state, potentially constituted a discovery violation. The court directed both parties to submit written memorandum addressing both the admissibility of the evidence and the discovery issue. After reviewing now the written submissions from the state and from the defense, and also listening to arguments this morning and a review of the applicable case law, the court will render its decision now. First, I want to start with the premise under State versus Knight 256 NJ 404 2024, quoting State versus Williams 80 New Jersey 472, 478 1979. Quote, the thrust behind the reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. With that being said, in looking at our New Jersey court rule 3:13-3B2B requires the defendant to provide to the state, quote, any relevant books, papers, documents, electronically stored information, and any other data or data compilations stored in any medium from or through which information can be obtained. The phrase electronically stored information is broad and encompassing a wide range of digital evidence, but it includes and is not limited to text messages, emails, photos, videos, location data, metadata, and other information stored in electronic form. Rule 3:13-3F provides remedies when a party fails to comply with discovery obligations. The rule states, quote, "If at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with this rule, the court may order the party to provide the discovery, grant a continuance or delay during the trial, prohibit the party from introducing in evidence or material not disclosed, or enter such other order as it's deemed appropriate," end quote. Critically, Rule 3:13-3F also imposes a, quote, "continuing duty to provide discovery," end quote. In other words, discovery obligations do not end when initial discovery exchanges are completed. If a party learns of additional discoverable material at any point during the proceedings, including during trial, the party has an immediate obligation to disclose that material to the opposing party. In this case, the defense has relied on State versus Tier, where the Supreme Court held that Rule 3:13-3 does not require a defendant to generate a written witness statement where none exists. That's Tier at 228, NJ at 568. Tier protects attorney work product, specifically written summaries or notes that defense counsel creates during the investigation. The court in Tier emphasized that compelling defense to create statements would invade the attorney-client relationship, reveal defense strategy and theory, and violate the defendant's Sixth Amendment right to counsel. The court did not address and specifically did not decide what obligation a defendant has with respect to independently created physical or electronic evidence that exists separate and apart from any work product created by defense counsel. In Knight, the Supreme Court addressed a question Tier did not resolve. What happens when independently created physical evidence exists and defense has access to it? There, the court held that an affidavit not created by defense counsel must be disclosed under Rule 3:13-3B2B. The court indicated, quote, "The affidavit is physical evidence of a crime. It's not the product of the defense investigation or attorney work product. Rather, the affidavit is a relevant writing, potentially in defense counsel's possession, pursuant to Rule 3:13-3B2B. There is no question that this type of physical evidence falls squarely within the defendant's required reciprocal discovery obligations." That's Knight, 256 NJ 404,422, 2014. The court distinguished previous cases before the court in State versus Mingo and State versus Williams of turning over inculpatory evidence. The court in Knight also rejected Sixth Amendment concerns. Quote, "No such concern is present in this case, however, in which the item in question is physical evidence and not the product of defense counsel's investigations." That's Knight at 423. Significantly, Knight uses the phrase, quote, "potentially in defense counsel's possession," rather than actually in defense counsel's physical possession. In this case, we know that defense counsel physically had possession of a screenshot of a communication between Caitlyn Cano and Jesse Caneiro, where the document specifically shows that at some point in time, the text message was read. That item was never turned over to the state at any point in time until well after the testimony. The court now applies this legal framework to the two pieces of electronic evidence at issue in this case, beginning with the text message screenshot. Here, the text message screenshot depicts electronic metadata showing that a message sent by Katie to Jennifer now displays a status of, quote, "read," end quote. First, as to the origin of the screenshot, the, quote, "read," end quote status was created by the iPhone messaging system, not by defense counsel. When Jesse Caneiro's phone or other device logged into her iMessage account, opened Katie's message, the messaging system automatically generated the, quote, "read," end quote status and transmitted that information back to Katie's device. This is a function of how the iPhone iMessage system operates. It's not something that defense counsel created, directed, or had any role in producing. Similarly, the screenshot itself was created by Katie Cano, not by defense counsel. Katie took the screenshot on her own phone and then transmitted it to defense counsel. Under Knight, this electronic evidence, quote, falls squarely within defendant's required reciprocal discovery obligations, end quote, because it is, quote, not the product of defense investigation or attorney work product, end quote. Second, as to the discoverability, the text message screenshot unquestionably qualifies as electronic stored information. It is a digital image file depicting electronic metadata from an iPhone messaging application. It is stored on Katie's phone and was transmitted electronically to defense counsel's phone or computer. This is precisely the type of electronic evidence that Rule 3:13-3B2B contemplates. Moreover, defense counsel actually received that screenshot on February 8th, 2026, according to defense counsel. Defense counsel had that screenshot in her possession when Katie testified on February 9th, 2026. Thus, defense counsel had actual physical possession of the electronic file. The fact that defense counsel chose not to introduce the screenshot as an exhibit at trial does not change the discovery obligation. Defense counsel's strategic decision about how to use the evidence, whether to present it through testimony describing it or through introduction of the exhibit itself, does not eliminate the requirement to disclose it to the state. It's Discovery Rule 3:13-3B2B. Finally, the defendant's argument assuaging noncompliance are unavailing. Under Rule 3:13-3F, there is a continuing duty to provide discovery. The fact that the defense counsel received the screenshot only one day before Katie was scheduled to testify, according to what she has said, does not excuse the failure to disclose. Further, the defense's reliance on Tier misunderstands the distinction between Tier and Knight. Tier protects defense counsel from being compelled to create written summaries or oral written statements. Tier does not protect defense from disclosing independently created evidence that defense has the ability to obtain and had it in her possession. Because the screenshot was created by Katie and the messaging system, not by defense counsel, Knight requires disclosure regardless of whether defense counsel ultimately introduces it as an exhibit. Therefore, this court finds that the defendant violated its discovery rule obligations as it relates to the text message read status of the text message between Katie Caneiro and Jennifer Caneiro. As to the GPS, the iPad location data was created by a location sharing service or application, not by defense counsel. While the parties have not identified the specific service Katie used, common location sharing services include Find My Phone by Apple, Life 360, Google Location Services, and similar applications. These services use GPS technology to track the location of devices and share that location information with authorized users. When Jesse Caneiro's iPad shared its location with Katie's device, the location sharing service generated GPS coordinates, timestamps, and other metadata showing where the iPad was located at various times. This data was created by the technology, not by defense counsel. Defense counsel played no role whatsoever in the genesis of this electronic evidence that was created by the witness's actual iPhone. First, location sharing data is unquestionably electronically stored information within the meaning of Rule 3:13-3B2B. The rule specifically requires disclosure of electronically stored information and any other data or data compilations stored in any medium. Defense counsel states that the defense simply has what was verbally relayed during a recent witness prep session. However, the test under Knight is not limited to evidence that defense counsel has already obtained and is physically holding. Knight uses the phrase, quote, potentially in defense counsel's possession, end quote, indicating the test extends to evidence that the defense counsel has the ability to obtain. Defense counsel argues that Tier protects Katie's testimony about what she observed because defense counsel has no written statement or document to turn over. Defense counsel contends that Katie simply told counsel orally what she saw, and Tier holds that defense counsel need not create a written summary of the oral statement. This argument fails for the same reason it fails with respect to the text message screenshot. The issue is not whether defense counsel must create new work product summarizing what Katie said. The issue is whether defense counsel must obtain and disclose independently created electronic evidence that exists separate and apart from any work product, or at least to ask about it. Caitlyn Cano did not merely remember seeing something. Katie used a location sharing service that generated electronic data. That data exists or existed in electronic form. It was created by technology, not by defense counsel. If defense counsel had the ability to obtain the data from Katie, then defense counsel should have requested it, or at least indicated to the state that it does not exist. Tier protects, as I indicated, work product created by defense counsel. Tier does not protect defense counsel from the obligation to obtain and disclose independently created electronic evidence within defense counsel's control. I should also point out, as it relates to the location sharing, that defense counsel indicates in a footnote on page 2 of her brief that she must have learned through her conversation. I'll just use her words. It should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it, either via text message or phone call, once she saw that she had the location, and asked him why he taken Jesse's iPad. Why he had taken is probably what she meant to say. Corey then turned off the location. However, so in that circumstance, that is more information that if the state had that information in advance, would have had the opportunity to actually investigate whether that phone call or text message actually existed, had the opportunity to reach out to Corey Caneiro, and if they wanted to or so choose to figure out if that existed. In this particular case, which at some point they did not feel that they needed at the time that they originally interviewed her. What happened here is that defense counsel put the state in a position by not providing any information as it relates to that metadata for the puts the state in a position where they did not have the opportunity to even investigate, which is exactly what I said from the beginning, that State versus Knight talks about, that the thrust behind reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. Okay. So, with that being said, defense counsel devotes substantial portions of the written submission to arguing that Katie Cano was available to the state for more than 6 years, and that if the state wanted to learn about the evidence, the state could have re-interviewed Katie at any time. This argument fails to excuse the discovery violation for several independent reasons. Number one, discovery obligations are independent of the state's investigation. Under Rule 3:13-3B, it imposes discovery obligations on the defense that exist independently of what investigative steps the state has or has not taken. This rule does not contain an exception stating that a defendant need not disclose evidence if the state theoretically could have discovered it through independent investigation. If defense counsel's argument were accepted, it would eviscerate the reciprocal discovery rule. Under defense counsel's theory, a defendant would never have to have a discovery obligation with respect to any evidence that the state could have found on its own through a diligent investigation. This would include written statements, documents, physical evidence, and electronic data. The defendant could simply wait to see what the state discovers and then spring any additional physical evidence or electronic data, arguing that the state should have investigated more thoroughly. Second, the evidence did not exist when the state interviewed Katie. Defense counsel argument in that area also fails. The state interviewed Katie Cano on November 20, 2018, the day after the murders. At that time, the text message did not yet display a read status because Katie had not yet checked it after Jennifer's death. At the time, Katie had not yet tracked the iPad location of Corey's residence because it did not occur until February 2019, several months later. The state cannot be faulted for failing to ask Katie about evidence that did not yet exist at the time of the interview. The notion that the state should have conducted follow-up interviews with Katie every few months for the next 6 years on the speculation that she might someday check our old text messages, track an iPad location, is unreasonable, and this court finds no support in law. Defense counsel argues, as a third point, that it would be unfair to penalize the defense for recently learning information that the state could have discovered years ago. This argument actually supports the state's position rather than the defendant's position. If the timing of when parties learn information matters for purposes of fairness, then the relevant comparison is not between when the state first interviewed Katie in 2018 and when the defense counsel interviewed Katie in 2026. The relevant comparison is between when defense counsel learned about this evidence and when the state learned about it. Defense counsel learned about the iPad location on either January 30th, 2026 or February 8th, 2026, based upon defense counsel indicating that she had prepped Katie Caneiro for the first times for her testimony on these two particular dates. Defense counsel obtained the text message screenshot on February 8th, 2026. Katie testified on February 9th, 2026. Defense counsel had somewhere between 1 day and 10 days to disclose not just the evidence for the text message, but also the iPad location information so that the state could have had the opportunity to take a look at it and investigate it. The state has literally had zero time to investigate any part of this information, to verify it, to contradict it, to subpoena for more information, or anything in that matter. If fairness and timing matters, as defense counsel argues they do, then the fair result is to give the state the same opportunity to investigate that defense counsel had. That is precisely why the continuance would be accomplished if it was requested by the state. There are questions here that the state cannot answer simply through cross-examination of Katie Caneiro. These questions potentially require investigation, consultation with technical reports, forensic evidence of Katie's phone, review of service provider records, and potentially interviews of other witnesses, including Corey. The state cannot conduct this investigation while Katie is on the witness stand testifying before the jury. The state would need time to investigate before the evidence impacts jury deliberations. The state has indicated before they heard my decision that they would that they did not want a continuance for any reason. However, before I finish this opinion, I'm going to give them the opportunity, after hearing the opinion, to make any decision that they would like to make. The court is relying on 3:13-3F, where the trial court is afforded wide latitude to resolve discovery disputes. Moreover, in appropriate circumstances, the court can either order discovery of items beyond the scope of the discovery listed in Rule 3:13-3. However, in this case, under the circumstances, the court is not going to use the draconian remedy of actually barring some of this evidence, and I'll go through it in a minute, but the court would consider a continuance for the state if they needed more time to look at this. However, let me say this. As it relates for the rationale behind the reasoning for the GPS testimony, which the defense says this testimony is relevant because, and this is relating to the GPS location of where Jesse's iPad was located for two reasons. One, it demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Vought's Detective Vaught.
My apologies, that was the third time.
Can we go off the record for a second? Okay. For the record purposes, an individual was removed from the courtroom for reasons for the Sheriff's Department to take care of. I just want to go back and say for the two reasons why the defense believes that this is admissible, the GPS locations. It demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Vaught regarding the Tiffany's jewelry boxes found on top of the fire rubble, both of which occurred prior to Vaught's collection of DNA samples in 2020. Second, that it demonstrates a failure to investigate for whatever reason. The police did not seize or search the iPad, while they did seize or search Sophia's phone. I will take them in order. As it relates to any type of Corey's taking of these items out of the house after the homicide, the court had rendered a decision on January 27, 2026 in a 42-page opinion outlining what behavior and what instances that would be allowed to be elicited by the defense of either Corey Caneiro or if there were certain other witnesses that took the stand as it related to Corey Caneiro. The court, in that order, court specifically said that it found as wholly inadmissible any alleged post-crime suspicious activity involving Elisa Caneiro and Corey Caneiro. In this circumstance, the allegation that Corey went into the home and took out the iPad, allegedly, because at this point in time, there's testimony about a GPS location. I don't know if the state's going to end up asking for a period of time to actually look at the witness's phone to find out if the GPS actually is there or not. But right now we only have testimony about that. And the reality is I have no evidence in this case other than that at some point in time, potentially, Corey had Jesse's iPad. I was supplied in this submission by the defense a photograph of the kitchen of Keith Caneiro's home that had an iPad there. That iPad, whether that's Jesse's or not, that's what is being offered by the defense, that it's Jesse's, and that Corey may have taken it. But Corey also was responsible for taking over everything after Keith and his entire family was obliterated from this planet, and Corey was left to handle all of the issues that were relating to the estate of this. So I can't find, under these circumstances, that Corey taking items from the house is relevant. I find that under 403 that it actually would be a confusing issue for the jury, because the probative value is significantly outweighed by the prejudicial effect of trying to understand, first, was it Corey that actually took it out of the house? Was it somebody else that took it out of the house and gave it to Corey at some point in time? Was it, who knows? The answer is that no one knows that. There's no testimony to that. There's no connection that has been shown, at least at this point in time. So the fact that the allegation is that Corey took items out of that house is not something that this court finds that would overcome a 403 analysis. The second issue is one that's something that's more in line with what I can understand. The second issue deals with a failure to investigate because the police did not seize and search the iPad while they did seize and search Sophia's phone. As it relates to what the investigation revealed and what it may not have, what they did and what they didn't do, that is relevant overall in this particular case. The issue in this case is whether there was other evidence in this case that would point to a different individual other than Paul Caneiro. And the investigation and looking into other areas such as the iPad, I do find to be relevant. I do not find under 403 that its prejudicial effect would be outweighed by the probative value. So I am going to, for purposes of this testimony, that I will allow the fact that the iPad has been was taken out of the home. However, the testimony as it relates to the GPS location is something that I'm going to strike from the record. There is no relevance to that other than under 403 as an overall thing, that there would be a confusion, that the prejudicial effect because of that confusion outweighs any probative value. So we can handle that in one of a few ways. Number one, there can be an agreement that Jesse's iPad, that there can be a stipulation that Jesse's iPad was not searched, was not taken and or searched, or some other type of stipulation that you can come up with. But there will be no testimony as it relates to this iPad until someone can give me a proffer in advance of exactly what's going to be said about it. defense counsel, out of fairness to the defense, offered up some suggestions. I'll leave it to the state and the defense if they want to come up with something that would be, that they feel would be fair to both sides. However, the admissibility of the GPS location as it relates to the two reasons why that the defense wants to bring it in, the court does not find under those circumstances that it would allow the GPS location in. Again, it will allow the fact that the iPad was not seized or searched, but as it relates to GPS location, this court has difficulty with understanding how there is a connection between where the iPad was located, especially when the defense is specifically saying in their submission that they are not saying that the iPad was taken during the murders, that the iPad was located still at the house after the murders, that there's no connection to Corey Caneiro or third-party guilt as it relates to that particular iPad, that I do not find a connection there under Codeditch, and I would not allow that in for purposes of any third-party guilt. But like I said, I would consider it for purposes of a failure to investigate. As it relates to the text message, as I indicated, I'm going to ask the state now if the state would like some time to investigate and or whatever that they need to do. I would entertain that. If the state decided that they did not want time to investigate, I am going to give them latitude as to the cross-examination in this specific area of the witness as it relates to that screenshot and how it was provided, when it was provided, and how that all took place. So with that being said, that's the court's decision that even though I do find discovery violations on both, I find that under these circumstances that the draconian remedy of excluding them for the reason of a discovery violation is not what this court is doing. However, in looking at the actual items, I have made rulings as it relates to my understanding of the evidence rules and how it should be allowed in or not allowed in. So with that being said, to the state, I'll give you the opportunity to let me know if you want what your preference is under the circumstances, and also if you want some time to speak to counsel as it relates to a stipulation as to the second part of Jesse's iPad.
Sure, Judge. I think Ms. Wallace is going to talk to Ms. Mastalone about the iPad. I'm going to go inquire. I highly doubt I'm going to ask for any more time other than 10 to 15 minutes just to think about it.
Okay.
The only question I had, Judge, with respect to clarification of
Sure.
the court's order, obviously they heard it was read, part of that testimony, but we got that document in the brief last night. Is the defense allowed to utilize the actual screenshot?
Well, let me ask you this question. Does the state, under the circumstances that it's been put in, would you want to use that on cross-examination and to go in the circumstances surrounding that testimony that you already have? Because, as I indicated, I'm going to give some latitude because of the fact that I do find it is to be a violation, but I do find that under these circumstances that I'm going to allow it in because somebody opened it. It's already out there. And I don't think that I can clear that out of the jury's mind. And I think it's really at this point in time the preference of the state. And again, if you want a few minutes to think about that, I'll give you the opportunity to do it. And again, if you need more time, then all you have to do is ask for that. And out of fairness, I would give you that opportunity to have more time. I don't want anyone, either side here, to sit here and worry about the trial and how long the trial is going or how quickly it's going. It's truly your own prerogative for the state, and you and Ms. Wallace should have the opportunity to think about it now that you have my decision.
Okay, Judge, yeah, I would just like a little bit of time to think about that.
Okay, why don't we meet back here at 10:45? I'll give you 30 minutes. If you need more time, you can let me know. We're going to tell the jurors downstairs we're in a little bit of a holding pattern, and I'll have them more do that. I won't address them myself, just to let them know so that they get an idea of what's going on. Okay?
Thank you, Judge.
All right, thank you.
Court is back in session.
Okay. Everyone can be seated. Sure. Ladies and gentlemen, we're going to break to give the state a little bit more time. We'll start back up at 1:30.